Hello, doctors. I'm Dr. Chris Rapoff of QME Continuing Education. Welcome to this week's Case Law Update. This week, the Workers' Compensation Appeals Board is asked to reconsider a prior ruling provided by the Workers' Compensation Judge. Here, the applicant felt that there was medical evidence crucial to the case that should have been reviewed prior to the conclusion of the work comp claim. However, initially the Workers' Compensation Judge didn't seem to think so. So who was right? Should the Workers' Compensation Judge have waited to consider the medical evidence prior to ruling on the case? Or was he right by ruling without it? You be the judge. Here we have the applicant, Mr. Regel, seeking reconsideration of the findings and order, wherein the Workers' Compensation Administrative Law Judge found that Mr. Regel did not sustain an injury arising out of the employment and during the course of employment, which we know as AOE-COE, and he ordered that the applicant take nothing. Mr. Regel contends that as Workers' Compensation Judge erred in not finding AOE-COE, and that the trial proceeded over Mr. Regel's objection and his request for a continuation so they could allow receipt of crucial medical evidence that he felt was very pertinent to his case. So the facts of the case here are that Mr. Regel claimed that he suffered an industrial injury to his neck, wrist, hand, back, and multiple other body parts while he was employed by Big Lots as a shipping clerk from the period of December 21 to December 22. Now, the defendant denied the claim in January of 23 and listed the lack of medical evidence as one reason for the denial. So in April 2023, the defendant filed a declaration of readiness and a mandatory settlement conference time concerning AOE-COE issues only, and again noted that the lack of medical evidence was the issue. 1 month later, Mr. Regel's attorney filed an objection to that declaration for readiness to proceed, and one of the reasons were that they were not allowing crucial medical evidence to be entered prior to the decision being made in his case. Now, the case proceeded to trial in June of 23, and Mr. Regel testified that he was actually hired as a shipping clerk by Big Lots in February of 2020. And he said his job consisted of lifting and stacking boxes. He said he started feeling pain in February or March of 2021 and sought the help at a regional medical clinic 5 or 6 times in 2021. He mentioned that he did not report the injury to his employer, and his last day of work was December of 22, and he did not seek any medical treatment after that date as well. He also mentioned that he was suspended and eventually fired by his employer. Now, the defendant produced a witness, and she testified that she was involved in investigating and eventually terminating Mr. Regel. The witness also described Mr. Regel's job duties as involving working from a conveyor, removing merchandise that weighed up to 75 pounds, and stacking the merchandise on pallets. At the conclusion of the trial, the judge found that Mr. Regel did not sustain an injury, AOE-COE, and ordered that he take nothing. As part of the analysis, the judge found that Mr. Regel was not credible, although no other information was provided with regard to that. In their discussion, the appeals board reminds us that the employee bears the burden of proving the injury that arose out of and during the course of their employment by a preponderance of the evidence. Now, whether an employee's injury arose out of and in the course of the employment is generally a question of fact that is determined in light of a particular circumstance of each case. The phrase, quote, in the course of employment, ordinarily refers to the time, the place, and the circumstance in which the injury occurs. An employee is in the course of employment when he does those reasonable things that would contract with his employment expressly or impliedly permits him to do. So for the injury to arise out of employment, it must occur by reason of a condition or incident of the employment. That is, the employment and the injury must be linked in some causal fashion. Now, the appeals board continues, and they're stating the actual facts that an injury may either be specific, which occurs as the result of one incident or exposure which causes a disability or need for medical treatment, or cumulative, occurring as a repetitive, mentally or physically traumatic activities and extending over a period of time, the combined effect of which causes a disability or need for medical treatment. Now, the date of injury is defined as, in a specific injury, cases that the date during the employment on which occurred the alleged incident or exposure for the consequences of which a compensation is claimed. It's a specific injury. Date of injury in cases of occupational diseases or CT injuries is the date in which the employees first suffered the disability and either knew or in the exercise of reasonable diligence should have known that such a disability was caused by the present or prior employment. Now, Labor Code Section 5412 requires both disability and the knowledge that the disability was caused by the employment. I just wanted to review these with you prior to making their decision. To no one's surprise, the appeals board stated that the judge's original decision must also be supported by substantial evidence in light of the entire record. Now, the term substantial evidence means evidence which, if it is true, has a probative force in the issues. It's more than a mere scintilla and means such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. It must be reasonable in nature, credible, and of solid value. Now, medical evidence is required if there's an issue regarding compensability of the claim. For instance, 4060, 4061, and 4062. A medical opinion must be framed in terms of reasonable medical probability and based on an adequate examination and history, must not be speculative, must be set forth reasoning to support the expert conclusions that are reached. Now, they also state that medical reports and opinions are not substantial evidence if they're known to be erroneous, or if they're based on facts no longer germane, or here we go, inadequate medical histories and examinations, or incorrect legal theories. A medical opinion also fails to support the board's findings if it's based on surmise, speculation, conjecture, or guess. No surprise to us, but they just wanted to give us the reminders as they were preparing us for their ruling. They also mentioned that medical evidence that industrial causation was reasonably probable, although not certain, constitutes substantial evidence for a finding of injury AOE-COE. They also state that the burden manifestly does not require that the applicant prove causation by scientific certainty, just by medical probability, reasonable medical probability. Now, here Mr. Reggio claimed a CT injury, but the judge originally stated that he did not meet his burden of proof to support industrial causation and ordered that Mr. take nothing. Also, in coming to his conclusion, the judge found that his testimony, Mr. Reggio's, was not credible. However, they didn't provide us any understanding of that in his original ruling. So Mr. Reggio objected because he felt that he was, number one, entitled to a comprehensive medical legal evaluation with the QME to settle a current dispute with regards to compensability. But more significantly, he said that there was no medical evidence produced at the trial. And with respect to the issue of whether he had even sustained a cumulative trauma injury, medical evidence regarding the causation is key. And he stated that the judge did not allow this to happen. This may have been directed at the judge's original opinion and the judge himself, but they did state here that the appeals board and the workers' compensation judge have a duty to further develop the record where there's insufficient evidence on a threshold issue. The appeals board also has a constitutional mandate to ensure substantial justice in all cases. They even cite sections 5701 and 5906, where that authorizes a judge and the appeals board to obtain additional evidence. Here we go, including medical evidence. Now, the appeals board may not leave matters undeveloped where it's clear that additional discovery is needed, as in this case. So they returned this to the workers' compensation judge and recommended that the medical record be developed and then returned. So, in conclusion, that just proves that one thing, that no one is infallible. Here we have a workers' compensation judge that felt that Mr. Reggio's workers' compensation injury claim didn't meet the AOE COE threshold. But the judge didn't consider all the facts before making that decision. So, in essence, the judge's opinion was based on insufficient evidence of establishing AOE COE by not reviewing the crucial medical evidence before he made his decision. So there we have it, another ruling that revolves around the fact that a report and or a ruling in the world of workers' compensation must qualify as substantial medical evidence to be upheld in court. No surprise. Once again, doctors, I'm Dr. Chris Rapoff and wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I look forward to sharing some other interesting cases again with you very soon. Thank you.